All right, let's take you now back to our top story and take you live to Alexandra Magistrate's Court, where court is about to rule on murder-accused Bafana Mahungela's bail application.
Street, Parkmore. In the video, a person is observed wearing a light blue top, a dark hat and sunglasses, holding something in his right hand that appears to be clothing. 5. Number 72 8th Street, Parkmore. That is, a clearer footage was obtained compared to number 70 8th Street, Parkmore. 6. Number 125 8th Avenue, Parkmore. In the footage, a male person fitting the description from points 2 to 5 is seen disposing of some items by shoving them into a drain and then proceeding to walk up 8th Street. The police opened the drain and retrieved the cap. Kirsten Kluyts' father provided a photo of his daughter's cap, and the cap was recovered from the drain matched the one in the photo received from the father. No other items belonging to Kirsten Kluyts were found in the drain. After reviewing the video footage, the investigating officer concluded that Kirsten Kluyts was murdered between 08:06 and 08:15 in the morning. The officer further asserted that on the day of her murder, the applicant had followed Kirsten Kluyts, possibly monitoring her movements and intending to kill her. The route the applicant took when walking back from George Lee Park to his place of residence is approximately 1.4 kilometers. The investigating officer received information regarding the suspect, leading him to number 145 8th Street, Parkmore. When the investigating officer showed a photo of the man wearing the blue shirt to the applicant, he confirmed that it was him in the photo. Consequently, the applicant was then arrested. The state objects to the granting bail, citing concerns that releasing the applicant on bail may jeopardize both the safety of the public and the safety of the applicant. Mr. Masako, on behalf of the applicant, presented the following arguments. 1. The court must find that the application does not fall within the ambit of Schedule 5 and 6. According to the evidence presented, the offence is either theft or defeating the end of justice. In such a case, the state bears the onus to show that the applicant's detention is justified and in the interest of justice. 2. The state failed to prove a prima facie case against the applicant. It cannot be said that the state successfully rebutted the applicant's case because viva voce evidence carries more weight than evidence presented through a statement. 3. The court must find that the state's case is weak, if not non-existent. 4. The video footage is crucial, and therefore the court must have viewed it. The failure of the state to submit the video footage means that the court cannot rely on the evidence tendered by the state regarding the video footage. 5. Freedom is a founding right, and the applicant's assertion that he will stay home if released on bail has not been disputed by the state. 6. The state did not submit any evidence that the applicant is a flight risk or would not stand his trial. 7. The applicant's evidence was truthful and solid. Therefore, the applicant's actions in the light that he was in shock after discovering the body were reasonable. 8. If the court finds that Schedule 6 is applicable, then the personal circumstances of the applicant to a certain degree can be considered as exceptional circumstances. Ordinary circumstances can also be viewed as exceptional circumstances. The court should recognize that the applicant is an innocent person, and that in itself constitutes an exceptional circumstance. 9. Referring to the Oscar Pistorius and Road matters, where both men accused of murdering their wives and or girlfriends were granted bail. The dignity of a black man is the same as the dignity of a white man. Therefore, the court should release the applicant on bail. Mr. Masako contended that the court should therefore grant the applicant's application for release on bail. Mr. Bafana, representing the state, argued that the state, concerning the charges brought forth, did prove a prima facie case. Additionally, asserted that the applicant did not demonstrate the existence of exceptional circumstances that would, in the interest of justice, permit the applicant's release on bail. The court deems it prudent to address Mr. Masaku's argument that the video footage is crucial or material. According to his viewpoint, the court had to view the video footage, and due to the state's failure to submit it, the court cannot rely on the evidence presented by the state regarding the video footage. In other words, the state acted maliciously by withholding evidence that it intended to rely on during the bail application from the defense. Stated differently, in a bail application as in a trial, the defense must have access to the contents of the police docket. Section 60, subsection 14 reads as follows, quotation mark. Notwithstanding anything to the contrary contained in any law, no accused shall, for the purpose of a bail proceeding, have access to any information, records or documents relating to the offence in question, which is contained in or form parts of a police docket, including any information, record or document which is held by any police officer charged with the investigation in question, unless the prosecutor otherwise directs. Provided that this subsection shall not be construed as denying an accused access to any information, record or document to which he or she may be entitled for the purpose of his or her trial, close quotation mark. In State v. Dlamini, State v. Gladla and others, State v. Joubert, State v. Kitakat, 1999, 623 SCC at paragraph 85, the Constitutional Court held as follows, quotation mark. In the result, subsection 14, read restrictively as indicated, does not more than make plain that whatever access to the police docket an accused may have to be afforded in order to protect his right to a fair trial guaranteed by the Constitution, there is no correspondingly general right at the bail stage, close quotation mark. In State v. Dlamini, 199, 4 SA 626 to 627, the Constitutional Court held as follows, quotation mark. There is a fundamental difference between the objective of bail proceedings and that of the trial. In the bail application, the inquiry is not really concerned with the question of guilt. That is the task of the trial court. The court hearing the bail application is concerned with the question of possibility. The court hearing the bail application is concerned with the question of possible guilt only to the extent that it may bear on where the interests of justice lie in regards to bail. The focus at the bail stage is to decide whether the interests of justice permit the release of the accused pending trial, and that entails in the main protecting the investigation and the prosecution of the case against hindrance, close quotation mark. And lastly, in State v. Bronco 2002, 1 SACR Witwatersrand decision at page 535, the court held that a bail application is not a trial. The prosecution is not required to close every loophole at the stage of the proceedings, close quotation mark. The court maintains that a bail application is not a dress rehearsal for the trial. Furthermore, the court dismissed Mr. Maseku's argument, contending that this court cannot rely on the evidence related to the video footage. Despite the fact that in the bail application the applicant is not entitled to the contents of the case docket, the state provided photos, which according to the state constitutes parts of the video footage. Additionally, the state supplied a copy of the applicant's cell phone movements and a copy of the scene photos. The court is of the opinion that it cannot be asserted that the state acted maliciously. Since the defense did not request a postponement to consult with the applicant, the court does not attribute any malice to the state in this regard. The court lastly disagrees with the defense that there are any evidence before this court indicating incompetence on the side of the state. Mr. Maseku contended that the applicant's viva voce evidence holds greater value than the affidavits the state relied on. The court, however, deems this argument unfounded. While a bail application is a formal procedure, it is considerably less formal than a trial. Therefore, the evidential material presented need not strictly adhere to the rules governing oral or written evidence. Given the less formal nature of a bail application compared to a trial, both oral evidence and affidavits are accorded the same evidential value. With that clarification, the court will now turn its attention to the question of whether the state has proven a prima facie case. Once again, the court emphasizes that it's not tasked with determining the guilt of the applicant. That is a matter for the trial court to consider. In the South African law, a person can be convicted of a crime where the only evidence available is circumstantial evidence. Therefore, the court can consider the circumstantial evidence before court to conclude if the state did prove a prima facie case or not. It is well established that at this stage, the state's evidence concerning premeditated murder, robbery with aggravating circumstances, and rape primarily relies on the following circumstantial evidence. 1. Kirsten Kluyts, dressed in a blue t-shirt, black ski pants, a light colored cap and running shoes, wearing a pair of sunglasses, a watch on her right wrist, and holding a cell phone and earphones in her ears, passed the timekeeper for a third lap at 08:05 a.m. 2. Kirsten Kluyts enters the open gate and the applicant enters the very same gate at 08:06 a.m., approximately 1 minute and 30 seconds behind Kirsten Kluyts. 3. Approximately 08:17 a.m., Mr. Vespel picked up a cell phone and handed it to the timekeeper. 4. The cell phone and car keys belonging to Kirsten Kluyts is found on a path adjacent to the embankment where the naked covered body of Kirsten Kluyts is discovered. 5. The car keys and cell phone belonging to Kirsten Kluyts were not recovered at the place where the covered naked body of Kirsten Kluyts was discovered. 6. At 08:49 a.m., the applicant is seen leaving the area where the body of Kirsten Kluyts have been discovered. The applicant is dressed in a blue t-shirt belonging to Kirsten Kluyts. Kirsten Kluyts' ski pants, running shoes and cap is covered in the shirt belonging to the applicant. 7. At 08:52 a.m., the applicant was observed leaving the park. He threw something over the lock gate and then jumped over it. He heads down Holt Street towards Virginia Road. 8. On the video footage obtained at number 70 and number 72 8th Street, Parkmore, the applicant is wearing sunglasses. The state alleges that it is the sunglasses Kirsten Kluyts was wearing when she entered the open gate. 9. The video footage recovered at number 125 8th Avenue, Parkmore, the applicant is seen where he disposes of the clothing. 10. The applicant, except informing his girlfriend, Nomsa, his father and 2 other students, of his encounter at the George Lee Park, did not inform the police or any security officers. 11. The cause of death was blunt force trauma. Strangulation, smothering or pressure to the neck cannot be excluded. Schedule 6. With regards to murder reads as follows, quotation mark. Murder when A. It was planned or premeditated, B is not applicable. C. The death of the victim was caused by the accused in committing or attempted to commit or after having committed or having attempted to commit one of the following offences. Roman I. Rape or compelled rape as contemplated in section 3 or 4 of the Criminal Law, Sexual Offences and Related Matters, Amendment Act 2007 respectively, or Roman II, robbery with aggravating circumstances, or points 3 to 4 is not applicable. Regarding the charge of premeditated murder, the state's evidence suggests that the applicant followed Kirsten Kluyts entering the open gate just 1 minute and 30 seconds after her. Within 8 to 9 minutes of their entry, Mr. Vespel recovered Kirsten Kluyts' cell phone. In other words, within 8 to 9 minutes, Kirsten Kluyts became separated from her cell phone and her car keys. The applicant, in his own admission, admitted to undressing Kirsten Kluyts and putting on a t-shirt. After entering the park, he exited the premises approximately 40 minutes later by scaling a locked gate. During this time, he concealed the remaining clothes with his shirt, only to later dispose of them in a drain. Shortly thereafter, Kirsten Kluyts' lifeless covered body was recovered, revealing blunt force trauma as a cause of death. The possibilities of strangulation, smothering, or neck pressure cannot be ruled out. In Kekana versus the State, 629/2013, 2014, ZASCA 158, the 1st of October 2014, the court stated as follows, quotation mark, "In my view, it is not necessary that the appellant should have thought or planned his action a long period of time in advance before carrying out his plan. Time is not the only consideration, because even in a few minutes are enough to carry out a premeditated action," close quotation mark. In the light of the aforementioned, the court is of the opinion that the state has successfully established a prima facie case regarding premeditated murder. Concerning robbery with aggravating circumstances, the evidence presented in court indicates that Kirsten Kluyts' cell phone and car keys were recovered on a path adjacent to a running path. However, Kirsten Kluyts' wristwatch, earphones and sunglasses were not recovered. The applicant admitted to undressing her and later disposing of her clothes in a drain, where the police later found the cap. The state's evidence is that the sunglasses the applicant is wearing as per Exhibit D3 belonged to Kirsten Kluyts. The police recovered the cap in the drain where the applicant was seen disposing of her clothes. Upon examining Exhibit L124, the medical report revealed hemorrhage on the upper lip and inner lips, lacerations on the upper and lower inner lips, bruises and abrasions on the back of the left ear. Additionally, there were bruises on the inner aspect of the left arm, extensive hemorrhage on the muscles and deepest layer of the skin underlying the right and left cheek and chin. Minimal hemorrhage were noted on the deepest layer of the skin and neck muscle. These injuries were observed in the upper neck area at the level of the hyoid bone, situated in the front of the neck just below the chin. According to the post-mortem report, the injuries to the face and head were caused by a blunt object, and the injuries to the neck suggested strangulation, smothering, or pressure to the neck. The court is of the opinion that the state has established a prima facie case for robbery with aggravating circumstances. Considering the charge of rape, the post-mortem report indicated no obvious injuries on the external genitalia, the labia, anus, and the area surrounding the anus. The evidence before court is that Kirsten Kluyts was 14 weeks pregnant, suggesting sexual activity. The court is of the opinion that the absence of external injuries does not exclude rape. Examining Exhibit M2, DNA was collected from the body, and the state awaits the results. In the absence of DNA results, this court is of the opinion that the state has not proven a prima facie case on a charge of rape. In light of the aforementioned, the court is of the opinion that the bail application falls within the ambit of Schedule 6. That being said, the applicant must discharge the onus of proving exceptional circumstances that, in the interest of justice, will permit the applicant's release on bail. The applicant contested the strength of the state's case both in chief and during cross-examination. He heavily relies on the disclosure of his version of involvement as establishing exceptional circumstances, especially claiming innocence and acting out of fear that he would be wrongly blamed or arrested for Kirsten Kluyts' death or murder. As mentioned, The reliability and credibility of these versions can only be tested by the trial court. Disputes and contradictions exist between the state's version and the applicant's, which is a matter for the trial court to adjudicate. It is not the duty of this court to evaluate the applicant's version. Otherwise, it can be accused of making a provisional finding regarding the guilt or the innocence of the applicant. Given that the state's case has established a prima facie case on the charge of premeditated murder and robbery with aggravating circumstances, the court holds the opinion that ordinary circumstances, such as the applicant being 21 years old, a student, and financially dependent on his parents, or the potential impact of his detention on trial preparation, cannot be elevated to the status of exceptional circumstances. Mr. Maseko referred to the Oscar Pistorius and road matters. While the court acknowledged the equality of dignity for all, it holds the opinion that this case resolves around gender equality. The evidence presented indicates that Kirsten Kluyts was brutally assaulted with a blunt object, and possibilities of strangulation, smothering, or neck pressure cannot be excluded. Given the prima facie case against the applicant, the court is of the opinion that the applicant poses a danger to society, especially to the women in our community. The applicant disposed of her clothing, potentially eliminating valuable evidence, and failed to report his discovery to the South African police or security officers, either directly or anonymously. The court is of the opinion that the applicant took deliberate measures to avoid detection, eliminating any evidence that could incriminate him. Consequently, the court believes that the applicant did not flee the province because he believed that all evidence leading to him had been destroyed. After thorough consideration, taking into account the applicant's version and the evidence tendered by the state, the court finds that the applicant has not discharged the onus of proving any exceptional circumstances that would, in the interest of justice, permit his release on bail. Therefore, the applicant's application for bail is denied.